Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. Now, without any further ado, I would love to introduce our panelists who will be speaking this afternoon. Ladies first, I will go with Stacie Hausner. Stacie has mediated full-time since 2015. She has successfully mediated more than 1,000 cases in the areas of business, real estate, personal injury, employment, insurance coverage, construction defect, malpractice, civil rights, entertainment, and intellectual property law, really spreading the gamut there. She has an exceptionally high settlement rate due to her tenacity, her ability to quickly understand issues, calm and friendly demeanor, creative out-of-the-box thinking, and keen insight. Before joining ADR Services, Inc., Stacie had an extensive career as a litigator, practicing law at both defense and plaintiffs firms. She recently has been inducted as a Distinguished Fellow of the International Academy of Mediators and a member of the National Academy of Distinguished Neutrals. When she's not mediating, she's an adjunct professor at the Strauss Institute, where she has taught more than 30 dispute resolution focused classes. She also trains mediators for the United States District Court's pro bono program and presents frequent MCLE trainings on topics involving the optimization of settlement and negotiation outcomes. Thank you for joining us today, Stacie.
Thank you.
Next on our list, we have Mike Maguire, who is a full-time neutral with ADR Services, Inc., and whose mediation practice draws upon his extensive experience in all areas of personal injury and property damage. A successful and accomplished AV-rated attorney, Mike tried over 100 jury trials, scores of bench trials, and had responsibility for litigating or managing thousands of other lawsuits over his more than 40 years career. Serving as a court settlement officer, Mike has successfully resolved lawsuits for more than 30 years in a wide range of civil matters. His breadth of legal knowledge and his trial experience enable him to credibly assist mediating parties in reaching full resolution of their matters. Mike served as National ABOTA President in 2019, President of the Foundation of ABOTA in 2014, and is presently on the Board of Directors for the National Center for State Courts and Project Youth Orange County Bar Foundation. Thank you so much for joining us today, Mike.
Thank you, Katie. It's my pleasure.
And last but not least, our other Mike today, Michael Balmages, is a mediator, arbitrator, and discovery referee with ADR Services, Inc. As also an AV-rated attorney for over 50 years, Mike specializes in business, employment, and real estate litigation. For 7 years, Mike had what he says was the best lawyer job in the world as general counsel for the Ocean Pacific surfwear clothing brand. Mike's experience also includes mediating more than 500 cases and presiding over more than 1,000 mandatory settlement conferences as a temporary judge in the Orange County Superior Court. Mike is a former chair of the Orange County Bar Association ADR section. And some interesting facts about Mike: for more than 25 years, he's been the lead astronomer for the nature reserve at Rancho Mission Viejo. Mike and his wife, Mary, live in North Tustin and have been married for 53 years. They have 8 grandchildren who live nearby, and he's an expert in the Moreton Bay fig trees. Really a Renaissance man. Thank you so much for joining us, Mike.
Thank you, Katie. It just became 50 years as a lawyer in December, a couple of weeks ago.
Oh, wow. Congratulations.
And 53 years married last week. So.
Oh, wow. Extra congratulations. Any extra grandchildren to speak of?
Not since I posted that, no.
Okay, great. Well, I will go ahead and pull our presentation up and leave the program in your capable hands.
Well, thank you, Katie. Let's give you a little heads up about what we're going to talk about today. We're going to talk about confidentiality and mediation privilege, the rules and law governing confidentiality, and the mediation privilege, where it's relatively comprehensive, but simple in the title defines it. Then we're going to talk about procedural fairness versus outcome fairness and the concept of fairness in mediations. Lying in mediations, kind of recognizing a reality and trying to boil down through it. Neutrality and what issues arise in mediation. And finally, civility in mediation. And at the end, we will have handouts and links to resources provided that will be mentioned and discussed during this presentation. Next slide, please. Stacie, it's all yours.
All right. Well, thank you. I'm Stacie Hausner. As Katie said, I'm a mediator here at ADR Services, and it's a pleasure to be speaking here with you today. Thank you all for attending our MCLE presentation. So I'm excited that I get to start off our program and speak to you about confidentiality. As mediators, we tell you that everything communicated in a mediation is confidential. And we tell you this in an effort to get you to share information and to make compromises for settlement. However, this doctrine of confidentiality has limitations that you lawyers should know about so that you can protect your clients in the event that your case does not settle. So we're going to get into some of this with you right now. And next slide, Katie, please. All right, so there's three ways we basically discuss confidentiality in mediation. The first is the formal rules of evidence. What comes in, what's admissible in evidence at trial should your case not settle, and what is inadmissible and how that pertains to confidentiality. The second way we talk about confidentiality in mediation is with regard to caucus. So caucus are these private meetings that we have with lawyers and their clients, and we afford us another layer of privacy protection to these communications. And we call this confidential or private, whether we share it or not. That's important conversations that we have with the parties and their attorneys. That's another way we can have confidentiality protections. And then the third way we tend to talk about confidentiality is using that term kind of interchangeably with the word privacy. When somebody says to you, can you keep this confidential? In the real world, we think, okay, we shouldn't tell anyone. And so some people have the expectation that in mediation, yeah, no one can talk about this outside the mediation. That is not the case, but that is another way we can talk about confidentiality, and we can protect for that. So we're going to get into some of that as well. Okay, next slide. Okay, so I'm going to start with the first way, which is statutory protections. And we have rules of evidence to protect what is admissible in trial with regard to communications made in settlement. And federal rule of evidence, Rule 408 is clear that it's inadmissible communications made in a mediation are inadmissible to prove validity and invalidity of a claim. Impeachment statements can't come in. And it seems with this doctrine that some communications may get in for some collateral purposes, but it's pretty strict protections for communications made in a mediation if you're in a federal court. California Evidence Code is broader and less clear. Evidence Code sections 115 to 1123 are the primary code sections that govern mediation. And they basically say that anything written or said in a mediation is inadmissible in a non-criminal proceeding. This is pretty broad protection. They do this from a public policy standpoint because we really want to encourage people to compromise and try to get their cases settled. So the legislature has afforded these broad protections. Now it's a little vague, unfortunately. So we don't know exactly how protective it is in California. We got to be careful of that. We'll get into that. But California Evidence Code is protecting generally everything written and said in a mediation. Now, mandatory settlement conferences are different. They are governed by the rules of court. And there's reference to evidence code section. What we do know about it is we're pretty certain that numbers communicated, settlement offers and demands are protected from admissibility. We're not sure if everything said in that proceeding is protected.
Stacie,
Yeah, Mike wanted to jump in on this.
Yeah, I do want to jump in here because I've been in a lot of MSCs and they are different statutorily. You mentioned that. If you look at Evidence Code 1117B2, it says that the mediation privilege, in essence, the mediation privilege does not apply to MSCs. But practically, I don't see any difference here. I think this is a distinction without a difference. I am unaware, and you and I discussed it a little bit, I'm unaware of any case where MSC negotiations were admitted into evidence. And unless you or Mike are aware of something I'm not aware of, I really see this kind of as a distinction without a difference.
I'm not aware of anything either, and I know there's a lot of literature out there about whether this is really a distinction. There is not a lot of case law in general in California with regard to confidentiality, and that certainly applies to mandatory settlement conferences. So I appreciate you raising this point, and I do agree with you on it. So thank you. All right, next slide. Okay, settlement agreements. So this is a written communication in a mediation. These are not coming into court unless you waive it. So section 1123 is the section that allows for admissibility of settlement agreements in certain circumstances. So to be careful, I would waive section 1123 and put in the types of language I have in this blue box, which is the parties make it clear that the agreement is admissible or subject to disclosure. The agreement provides it's enforceable or binding. I'd put in those magic terms. The parties agree to its disclosure. And then if you want to use the agreement to show fraud, duress, or illegality, it can come in as well. So we have to be very careful when we're doing our settlement agreements to have the language that allows a court to look at the settlement agreement in case of a breach. Now here at ADR Services, we have short form agreements. We have that provision in the short form agreement. And when we settle a case and I forward this to counsel, I make sure that they see this provision, that they keep this provision in as they're signing their agreement. Now, the other thing I just want to point out here is that the court will only be able to look at the agreement. It will not look at all the communications surrounding the agreement. So it is very important that you make sure everything you need the court to see is in that agreement. So let me give you an example of this. Let's say a plaintiff decides to take less money because defense has represented that they don't have insurance. And because of this, let's say the defendant does not have a lot of money. And because of that, the plaintiff's taking 100 grand instead of $1 million or something. It is very important the plaintiff put that at least as a recital in the agreement, because what happens if later the plaintiff learns that the defendant really did have insurance? The court would never be able to hear these communications and know that you relied on that in the mediation if you don't have it within the document. So from a practical perspective, if I was an attorney, I'd make sure that my recitals contained everything that I wanted the court to see, and then I would make sure to make the agreement enforceable in a situation of a breach.
So Stacie, on a practical note on settlement agreements, and this is for a question for both you and Mike, what are you guys doing to get settlement agreements signed in remote mediations? And I've had a lot. I'd be curious to hear what you guys are doing.
Yeah, so I think it's very, very important you sign the agreement in the mediation. Why? Because all of us mediators can tell you those situations where everybody sleeps on it or it doesn't quite get done and the whole deal falls apart. So people, when they go home at night, they say, could I have done better? Why did the other side agree? They'll sometimes call me and say, should I have asked for more? So because of that, I think it's critical we get these agreements signed. I always ask counsel to do it. What I do is I ask there's two things I do. One is I'll ask counsel to bring an agreement or start working on agreement during the mediation. So if they require a long form, I will have them have it at the ready by the time we are ready to sign, so that all we have to do is plug in the terms of the settlement. I'll even have them start exchanging it in the mediation. If I cannot get them to do that, I will definitely give them our ADR services short form agreement. I will get that to them as early as possible and have them fill that out and sign it. We have DocuSign at our office, so sometimes I'll establish the DocuSign and send it out that way. But a lot of lawyers have capabilities as well to get their clients to sign it. But I think it's very important we sign agreements. What do you guys think?
I follow a similar procedure, Stacie. My pre-mediation letter goes out and suggests that anybody who's going to submit a settlement agreement have one ready. And we check with that at the beginning of the mediation sometimes. And then I've like to get the attorneys together at the conclusion of mediation when you have a settlement and just say, okay, I want to talk to the attorneys separately about the agreement, and let's make sure we got every term and every condition that is agreed. And right then you save the problem that occurs occasionally if you don't do that, of having someone think of another term or thought it was implicit and wants to add it, and now you've got a problem. So I usually like to have the attorneys together in a breakout room on the Zoom and both say, this is it, we got it. I'll get it to you this afternoon. And my client's here, we can sign it, we're in good shape. So I think that's a good practice.
So I do everything that you guys have already mentioned, plus maybe a couple more. Stacie, you mentioned the ADR services form that we have when we're in the office. I download that, or I send the lawyers to our website so they can download it, where they can fill out a handwritten kind of form. They often want a long form, and that's up to them. I don't think you need a long form once you have that one. But I've also used screenshots where people either didn't have fax machines or they didn't have any, or email access. They didn't have an ability to exchange the same document, where we get the parties, the lawyers, whoever's going to sign the agreement, to sign it and hold it up to the screen, and we take screenshots of it. So there are lots of ways to work around that. But I agree with both you guys. It's imperative to get it signed if you can that day. Although I'll say in personal injury cases, lots of times the plaintiff's firm has worked with the defense firm, and they both tell me, we'll take care of it. We don't need it. I trust these guys. I've worked with them 100 times. So.
All right. Well, thank you for that. Okay, next slide, please. Okay, when is the mediation over? This question is actually important because you may assume there's confidentiality protections when there is not. So mediations are over when you have a fully executed written agreement, or you have 10 days with no communication between the mediator and any of the parties. So if you call your mediator on day 11 or the other party or both, and you're assuming that means everything's protected still, it may not be. Now, I want to say, practically speaking, it arguably may be, because you have your mediator there, and this could be another mediator session. But just keep in mind, there would be an argument that the mediation is over. I tell parties to include me, CC me on their communications should a case not settle, or as they're drafting a long form agreement, so that it all stays under the privilege, also so I can jump in should there be any issues. But keep in mind, there could be some issues here. And if the parties agree and say the mediation's over, and the next day they want to start talking settlement again, that arguably may not be admissible. The code says it's not. Practically speak, I don't know what courts are doing. Again, these types of issues haven't gone up to make case law with, so we're not exactly sure. And I think it would be up to your trial court with what they're going to do about that. All right, next slide, please. Limits to confidentiality. So let's talk about what is not protected and why and when you should be careful with your communications in a mediation. So first of all, let me point out what the statute says, which it applies only to admissibility of evidence in a civil proceeding. So it is not making information private. And if your client does not want things said in the mediation to go to the media, Sometimes I've done cases involving high profile people. They may have reputational concerns. Sometimes I've done it with employers and all the employees know each other. Maybe things that they say in the mediation, they don't want to get out to the other employees or to the neighbors or to the friends or whoever it may be in under your set of circumstances. So this only protects admissibility in a civil proceeding. It does not protect information in a criminal proceeding. And those of you that practice business litigation probably have had experiences where a client may be under criminal investigation, or there's criminal allegations of embezzlement or fraud and this nature. Be careful, because the information you disclose during this mediation will come in a criminal proceeding, in an investigative proceeding. So it is only in a civil proceeding. And I will tell people I work with about that, should I know there be allegations like fraud or somebody tell me there's a criminal investigation. So be protective of your client in that instance. And also in state court, we don't know if it comes in for impeachment. Federal court, it does not. But what if your client says something totally different on the stand than they said in a mediation? Now, arguably, it could come in for impeachment. So keep that in mind. We don't know. It hasn't gone up to the state court. So if you're being very protective, be aware of these types of issues. All right, next slide, please. Okay, further limit. Confidentiality statutes do not really protect communications from discovery. Now, what I think it protects, and again, it'll be up to the trial court, you wouldn't be able to say, didn't you say in the mediation you have an offshore bank account? Okay. What it doesn't protect, it allows the other side, though, to take discovery about all your bank accounts. So they could prepare on discovery and say, give me all documents related to any onshore or offshore bank accounts. They could ask in deposition for you to list information about bank accounts. They can't talk about the communication, but you could open a whole box of information and discovery that the other side may not know about. I tell you this, it is against my interest kind of to tell you this, because as mediators, the more information you give, the easier it is for us to settle the case. That's why we sell confidentiality. However, you have to be careful if you're not past your discovery cutoff date. If this case is not going to settle, do you want the other side to have this information going into trial or not? And that's a balancing act as attorneys you have to do. Am I going to give it all now in an effort to settle? Am I going to hold some unless settlement looks likely? Am I going to be protective and ready for litigation? It'll be up to you what's in your client's best interest. But I think it might be helpful to keep this in mind and know of the potential here for danger for your client should your case not settle. All right.
Stacie, so that happens a lot. I get lots of times where counsel tells me a bit of information and I want to communicate it to the other side because I think it's important. If they want to settle the case, I think this is important information. And they give me that exact response. Well, I don't want them doing discovery over this thing. So that's one reason. I generally try to persuade everybody to give everybody everything because generally everything's going to be known before trial anyway. But there are lawyers that sometimes just don't want you to tell. And I think it's our obligation in that case not to tell that stuff. But I do try to convince them.
Absolutely. And that's why I brought it up, because it does come up all the time. And I'm very respectful of people's information management and their case. I would never want to do something to hurt their case. But I understand the instinct for you lawyers to say, I'm going to hold this right now. Maybe I'll give it in a little bit, but right now I just got to be protective of my client. So, of course, the more information we're looking as mediators to change the perspective of the other side, to get them to evaluate the case more similarly to you. And the more information we have as to that supports your position and makes their case risky or weaker, that's going to be beneficial to us. But I think it's very important that you look after your client in this regard. And I'm very respectful, and it comes up all the time. I agree. And that's why I'm bringing it up as, let's be careful here, people. All right, so thank you for that. Also, keep in mind, different states have different confidentiality protections. So California is very broad and vague, and I'm not really sure, and no one's really sure what the trial court is going to do. And we have some idea, but as Mike said, there's some distinct, we don't even know mandatory settlement conference, how and if they're different really than mediations. Other states are stricter, other states are clearer. And the truth is, we don't know what state law is going to apply. So now with Zoom especially, I have people all over the country, I have people all over the world making communications in my mediation. Is it the state where the communication is made? Is it the state where the case is filed? Is it the state where I'm located? I don't know. Nobody knows. So keep that in mind, because confidentiality varies greatly from state to state. And what you're used to being confidentiality protection here in California, it may actually not be in Colorado or Wyoming or New Jersey. So let's keep that in mind. Should you have people zooming in from all over the place? This wasn't as big of an issue, I think, before Zoom. Sometimes people would mediate out of state and it became an issue, but typically the mediations were held in the forum state, and now it's a jumble, communications all over. Keep in mind, it's the forum state judge that's deciding. So maybe they're going to use their own state law. Maybe they're going to use whatever law allows them to get it into evidence so they can make good decisions. I don't know, but something to be aware of and to consider. All right, next slide, please. Okay, so there is a Uniform Mediation Act, and there's about 12 states that have adopted it, and it has a lot of exceptions to confidentiality that we do not have here in California. So we see California is very broad. It seems very protective because of its breadth. But look at all these exceptions to confidentiality with the Uniform Mediation Act. So you don't have to waive confidentiality 1123 and say the agreement's enforceable and binding to get your settlement agreement in states with this act, because it's automatically in. It's an exception to confidentiality if an agreement is signed by all the parties. Documents required to be kept public, open to the public, are going to come in. So if you have a document in your mediation and you're hoping that it's not coming into court and it's required to be open to the public, they're letting it in. So they're worried about, they're prioritizing public concerns over your confidentiality. Threats to commit injury or conceal a crime or situations involving child abuse and neglect. These are types of things that therapists are allowed to report, and teachers and mediators aren't really in California. But in the states with the Uniform Mediation Act, those are all going to come in. I like that. Information needed by a mediator to respond to claims against them. So if you're suing your mediator, they typically wouldn't be able to talk about anything that was said in the mediation. They wouldn't be able to defend themselves. Uniform Mediation Act, they can. But look how broad this is. Evidence not otherwise available, or need for evidence outweighs the need to keep the information confidential. They're going to let it in if the evidence is not otherwise available. That's pretty broad. That makes your confidentiality protection pretty weak. So when you look at that and you know that 12 of our states at least have this type of exception to confidentiality, we got to, be careful about what state confidentiality law is going to apply. All right, next, please. Okay. Confidential, we've learned in the last 3 years, and since I've been a mediator, so when I started with mediation, we actually didn't have an answer to this, but now we know that not only does confidentiality protect communications for your civil proceeding, for your case, it will not be admissible in any civil proceeding, even a different one. So in this Cassell versus Superior Court case, the client was suing the lawyer for settlement offers and demands that were not communicated in the mediation. So the client had brought a legal malpractice action against the attorney. And the attorney goes to us, says, I am so sorry to hear that, but you can't get this into evidence. It is confidential, everything that's said in the mediation. And the trial court said, you're right. it's not coming in. Went up on appeal. The appellate court did not agree with the trial court and said, you know what? It can come in because that's not what the purpose of confidentiality statute. It's not to protect you lawyers from malpractice. It's to protect, to allow compromises and to get cases settled. The Supreme Court saw it like the trial court, and they said, look, the statute's clear. It's not coming in criminal proceedings. I mean, civil proceedings, excuse me. So we're going to uphold the trial court ruling. And legislature, if you don't like this and you don't want it to be so expansive, these confidentiality protections, you got to speak to it. So the legislature did. All the mediators jumped on it, and they wanted very protective confidentiality so people will be comfortable sharing information. The legislature passed SB 954, it's evidence code section 1122 and 1129. And now they require you attorneys to get a written acknowledgement from your clients prior to the mediation that they know mediation communications are confidential and inadmissible at trial. It's very instructive about size of font and what it needs to say. When this passed, I remember handing out these papers to lawyers so they could just have their clients sign it at the start of the mediation. Now, most of you lawyers know this and do this. If this is not part of your practice, you could get in trouble if they want to sue you for malpractice, but you'll be protecting yourself from that if you get these documents signed. So take a look at these evidence code sections. All right, next slide, please. What can we do given the limits to confidentiality? Well, what we know that a lot of lawyers ask us, put confidentiality in the settlement agreement. And so that means that essentially means that you can't talk about the terms of the settlement. Typically, it's not as expansive as you cannot discuss anything that was said in the mediation. So if you want that type of protection, and there's a lot of situations where I think you would want it, you will want to make strict contract for stricter protections and get a confidentiality agreement signed with the other side before the mediation. This is, high profile cases, you should absolutely be doing that. And any case, I've had cases where they're worried about subsequent litigation, or they have 50 lawsuits against them related to this medical device, and they don't want anybody hearing what happened in the mediation. And so they want these confidentiality agreements signed before. It is normal. It is a great practice idea. Be careful when you're drafting them that you do not accidentally give your client less protection than they ordinarily would get under the law. You don't want to forfeit any of these natural protections. And we've seen that in other states where people inadvertently are doing that. So just make sure it's thoughtful, well drafted. Don't just use some default agreement. And think about, do I want my client to have a lot of protection here or not so much? What's the advantage to your particular client? And then you can draft it accordingly. You can contract for what state law applies, right? We don't know what state law applies because of Zoom, and there's not a lot of case law, especially in California on this. We have other cases in other states. We know a Wyoming court in Larson versus Larson would not uphold Colorado confidentiality statutes, even though the mediation took place in Colorado and the confidentiality agreement asked for confidentiality law. So I don't know if the states will honor it. It certainly can try. But keep in mind, it's the forum state judge, and they're going to do what's in their best interest or what's in the best interest of their community. So keep that in mind. All right. Next slide, please.
Go back to the other slide a second, if you would, please. But Stacie, you say here, judges probably want the relevant mediation communications to be produced because they want to make good decisions. We exchanged slides beforehand, so I saw this, but I wasn't sure what you were referring to here.
Okay, so I would think that if the judge is the decision maker, they're going to want information so that they can make a good decision. So I would think that in general, that a judge would want information in and would decide favorably for allowing its admissibility if they're making a decision. That's not necessarily the case, but it's something we should consider when we're thinking about whether this is going to come in and how to draft these agreements.
Okay, so in a bench trial or an arbitration, it's probably going to
That's
come.
what
Okay,
that you
all
would
right.
want as much as you could get. Okay. That's what I have to say about our concerns with admissibility of confidential communications. Just be mindful of it. I talked to you at the outset also about this other layer of confidentiality or protection. And this is the layer in caucus. So we're in a private meeting and you can absolutely tell us, don't tell the other side this, keep this private. That is very important to me as a mediator. I'm assuming that's the same with the mics here, and with all mediators, that we honor and respect your information and your desire to use it or not to use it. In fact, when you say it to me, I have a red pen, I'm circling it, I'm starring it, like no way is that coming out of my mouth. What you want to establish with your mediator is how you want to deal with the exchange of this private information or information in general. You don't want the mediator to assume they can share the information when you really don't want them to. So there's these are fancy terms. I teach at Pepperdine Law School Strauss, and these are, as we train mediators, these are more fancy terms, but the gist of them holds true for all you lawyers out there. With the explicit permission model, that's when you'd basically say to your mediator, look, mediator, do not share any information unless I tell you you can share it. Now, if you don't trust your mediator, or if your mediator did something earlier in the mediation that makes you concerned, you may want to say to them this exact thing and use this language. Now, I caution you about this type of model for sharing of information in that it's highly inefficient and it could be disruptive of the flow of mediation. So if you were to say that to me, I'd have to summarize everything you say. Can I say this? Can I say that? That would take a lot of time. And then what if when I'm in the other room sharing your information, they ask me a question? And it's a question that could really help your side. I would not be able to share it. I'd have to march back, and it's easier now on Zoom because it's a click of a button. But it used to be marching down the hall at ADR. So we have big offices. I have to go back into your room, say, can I share this? They've asked me this. And how can I say it? And it would take forever. Book a bunch of sessions if that's the model you want to use, because I think it would really slow down the flow. It also might look a little suspicious to the other side as to why can't the mediator answer this? What are you hiding? So careful with the message. I'm not a huge fan of this model, but I want to present it to you as an option. The second model is this explicit reservation. And that's when you say, mediator, you can share anything productive to settlement. That's what we do. We don't badmouth you. We're trying to get the other side to move towards you. You can share anything productive to settlement unless I tell you not to. So unless I tell you to keep it private. That's a very typical way we can protect you in mediation. Sometimes you'll tell me something and I think, are you sure you want me to say this? And here's my concerns with saying this, or maybe we should hold this. Things like that when there's information you give me that might be harmful to you, I will alert you to it. And also you say, hold this, or between you and me. Those are the types of things with this explicit reservation model. And finally, with the carte blanche model, that I like, it's when you say, look, use your best judgment. Lawyers that have worked with me a lot, they tend to feel comfortable with that. And also when all the discoveries out there, people are a lot less guarded with the information, factually simple cases or cases right before trial. They're a lot less guarded. So whatever model you want to use, just give it some thought in how you want to talk to your mediator about it, and make sure that the information you want to give is given at the right time in the right way. I always say information is power, information management is very important. If you were to give me your most important point and I just delivered it with 10 other points. That's that argument dilution, right? Like they're not going to pay much attention. They'll focus on your weakest argument. So it's very important we deliver information at an impactful time. I will do this for you. You can do this with me. I assume most mediators work that way, but be mindful of that. You know, in Southern California, most lawyers want caucus the whole time and do this shuttle diplomacy, which is fine. So these types of conversations or considerations are important if you're using that as your process for mediation.
Stacie, oh, go ahead, Mike. Go
Jump
ahead.
I
in.
just wanted to emphasize that how important I think that is, that there's an understanding, explicit understanding up front about what information can be shared. And I like the second model myself the best, is that everything's okay unless you tell me, do not share this information.
So I do it a little bit differently at the end of each caucus, and like you, I think you're saying, Stacie, I do just about everything in caucus with no joint sessions or rarely joint sessions. At the end of each session of a caucus, I'll ask counsel, is there anything you said you don't want me to tell the other side? Occasionally they'll say yes. Most of the time counsel says, no, you can tell them everything. You know, that's generally the response I get. Sometimes they tell me things they want me to tell them. You tell them that we're going to do this. You tell them he's such a jerk. And I say, well, I don't think I'm going to tell them that right now, but thank you for giving me permission. But occasionally I'll forget to ask and I'll go into the other room and I'll say, excuse me, I got to go back because I didn't ask my standard question. And I will go back and say, hey, I forgot to ask you, is there anything you said you don't want me to share? But I do that at the end of each session to make it clear, to give them the opportunity to tell me no. Sometimes I can share everything but their numbers. They told me their bottom line or their top line or whatever, and I won't share that, but everything else I will. And I do encourage the sharing of just about everything.
Yeah, and I think that's a really good practice, and I do it too when I can remember to do that. But it's very important that we understand and we don't accidentally share something that they don't want us to share. That would be something I'd have nightmares over. It used to be studying for exams. Now it's accidentally sharing things. So luckily that hasn't happened, but I take that very seriously. Okay.
I'm sorry to hear you have those nightmares.
I know. Well, I get lots of nightmares. All right. So let me just sum this up. I appreciate your attention. I know we've gone through this for a while. Just be careful and don't just naturally assume everything's protected broadly, that your client's safe. I hate to say it, it's not in my interest, but that is the truth. Don't blindly sign confidentiality agreements. I know some mediators use them. Take a look at them, make sure it's not restricting what your rights are under the law, and make sure that that's in your best interest to be signing that. Be aware, even if you have a confidentiality agreement, some judges are not honoring them. So you just be aware. Make sure your mediator knows what information you don't want them to share in particular. That is very important. We are doing our best to move you towards settlement, and you trying to use your information in an impactful way to move the other side towards your evaluation of the case. And you want to help us do that and be protective as well. All right. Well, thank you so much for your attention. Mike, thank you for jumping in and participating with me in that. Do you have anything further you guys would like to add, or should we move on?
I think we'll get back into some of this stuff again as we go forward. So I have nothing at this point, but I'm sure we're going to hit on some of these subjects again.
All right. Well, we get the pleasure of Mike Balmages leading us with conversations about fairness.
Yeah, we're going to talk about the two aspects of fairness here, and I'm going to take the lead on this because this is an important thing to me, but I'm going to encourage both Mike and Stacie to jump in anytime that they want to jump in on this, because as I said, this is an important thing. First, I noticed that there is a question to me in the question and answers. I've written an answer, but I'll also do it orally. I was asked by attorney John Stevens, who I happen to know, how many push-ups I did today. So I want to tell John I did 120 push-ups today, so he can have that question answered. All right, so we're talking about procedural fairness and outcome fairness, and let's talk about outcome fairness first. Do we as mediators have an obligation to see that settlements are substantively fair? That's a fair deal, a fair solution. As I said, I'm interested to hear what Stacie and Mike have to say about this. But for me, the answer is an unequivocal no. That is not our job. Can we have the next slide, please? Slide 18. There you
Well,
go.
I do have something to say about that, Michael. I've heard, I know that you train temporary judges at the Orange County Superior Court on mandatory settlement conference. And I've heard you say that before, and I've adopted it at times, not often. But when I hear it's not fair, this isn't a fair result, I say, what we're here today is to try to resolve the case. And today it's not like we're in front of the tribunal making a ruling, and it's not exactly justice. It is what is smart, as you have trained many people, and not necessarily what's fair. And if you do that up front, sometimes it sets the tone, whereas they're not trying to get exactly what will happen at trial, but they're trying to resolve the case ahead of trial. And I think that helps a lot.
Mike, that's a perfect segue into what I'm going to talk about now. We didn't rehearse this, but I really appreciate that. In my introductory remarks, and so right at the outset, I tell the litigants that I will at no point tell them that they ought to accept an offer, pay a certain amount, or settle because it's fair. I tell them, and again, this is in separate caucuses. I do it with each side at the beginning. I tell them that I don't know what's fair. And I usually say that I'm not in the business of fairness, justice, or equity. Those to me are irrelevant considerations. And you see on the slide here, I kind of also say maybe also the facts and laws are irrelevant. Rather, I am in the smartness business. And sort of like you said, Mike, if they want justice, they should go to trial, because that result will be justice by definition. We're not talking about that today. I tell them I'll never know the law of the or the facts of the case as well as the lawyers or as well as you do, Mr. and Mrs. Litigant, but that's not going to stop me from giving you my opinion of what's a smart thing to do. Most of the lawyers buy into this and say that they've already told their clients this. So even regardless of that, as Mike said, on many occasions, a party will again start talking about what's fair again. The numbers are going back and forth. Conditions are going back and forth, and the party will say, well, that's not fair. And I'd let them say that a few times. And I said, just remember, I agree with you. It may not be fair, but we're not talking about fairness here. We're talking only about what's smart to do. Most of the parties accept this. And I think Mike's right. Bringing it up early helps a lot. And they're kind of relieved by it. It's one less aspect of the case for them to worry about. I had a case involving, this is one of the first times I learned this, and this is a long time ago. I had a case involving a former teacher who was being sued by her former pupil for molesting the pupil many, many years ago. Pupil was 8 at the time. The pupil is now 18 and was suing. The teacher had actually served time for this crime. Interestingly enough, we were meeting in one office for the mediation, and the teacher would not come into the office, wouldn't even come onto the same floor that the student was at, because there was this impermanent restraining order of her being within so many feet of the pupil. So I had to go between floors to do this. I met with the plaintiff first and her counsel. Then when I went down to meet with the teacher, she cried. She started crying and tell me that she had not done what she was accused of doing, that she'd been wrongly convicted, but that everyone was telling her that was fair that she pay the former pupil. And I told her, frankly, I said, I don't know whether it's fair or not. I don't know the facts. I don't, you're telling me you didn't do it, and very possibly you didn't. And you may be very right that it isn't fair. But regardless of whether it's fair or not, based upon what I knew about the case, I thought it was smart for her to pay to get out of this case. Smart for her to avoid going through this whole drama again, having it in trial again, everything being brought up again. She told me that I was the first person to not tell her that it was fair that she pay, and that was a great relief to her, and she settled the case. In a very recent case, the defendant was accused of stealing the business from his former partner. The defendant was represented by a group of high-powered lawyers, and it looked to me like there was probably liability, and we were just going to be negotiating damages. After several hours, the lead defense lawyer said to me, Mike, tell us what's fair. We will pay what you think is fair. Occasionally you hear that, and I was not expecting that from these lawyers. Specifically, this lawyer wanted to know if the latest demand was fair. And I said, I would not do that. I reiterated, I don't know what is fair. I said, let's work towards a number that's smart under all the circumstances. Next slide, please. There we go. So this isn't an actual one I've used, but I have done this many, many times. That's my handwriting. That's my signature there. On many occasions, when a litigant keeps telling me this isn't fair, I say, you know what? I'll agree with you. It's not fair. In fact, I'll give you a writing. On this legal pad, I'll write it out. This is not fair, and I'll sign it, just like so as shown here. And I do that. I take the pair, I write it out, sign it, and hand it to the defendant. And almost always that moves the case towards settlement. The defendants seem to really appreciate it. Now, I'm saying defendants, it can also apply to plaintiffs, and it does apply to plaintiffs. Okay, I know that this violates my I don't know what's fair policy, but it's a little bit of empathy that seems to work wonders. Stacie and Mike, what do you guys think about us as mediators working towards fair settlement?
Yeah, that's a great question. I hear fairness all the time in mediation. This isn't fair. That's not fair. If they don't like how someone's moved or what someone said, it's not fair. Obviously we want to try to get the parties to be thinking about this from a business type of brain, whether it makes sense to enter into this agreement or if it's a smarter decision for them to pursue litigation. Outcome fairness, I don't think we can police that, because we cannot be neutral if we are worried about the outcome. And I even say at the outset, look, if $1 works for plaintiff, $1 works for me. And if $1 billion works for defendant, $1 billion works for me, right? Whatever they want is fine with me. I'm not putting my judgment on it. I am not them. I'm new to this dispute. I'm new to knowing them, and it's up to them as to what is fair. Now, what is a good settlement. So I am trying to have our conversations be about, risks and costs and weaknesses in the case and those types of conversations, as opposed to fairness, because what's fair to them is not going to be fair to the other side, or it's such a subjective term. So I do not police for outcome fairness. I do not even know what fairness means. I do make sure the process is fair, and that we will get to, because that is my obligation. But when they're talking about fairness, I do listen. I don't change the conversation. One, I think it's important they share with me why it's not fair. From that, I can learn their perspective. I can learn what they feel about what's happening with this process. I can learn about their interests. I can learn about what's important to them. So I will engage in those conversations because if they bring them up, because I do find it insightful and helpful for me towards settlement. But
So Stacie, so I listen too, but only to a point.
Yeah.
I mean, just so many times I get back to fairness, and that's when I come up with, hey, you're right. I'll sign a document says it's not fair, but I tend not to let them go on and on. So Mike, what's your thoughts on this?
Well, I practice more like Stacie. I listen to them, but eventually, if it's derailing the mediation because they're interested in fairness and not in settling, I have the conversation that we're here to make, as you said, a smart decision today. Decision to make sense under all the circumstances. You've already said you're willing and wanting to resolve the cases, and today is a good day to do that. So let's concentrate on those concepts, and what you think is fair, the other side may not. And if we're going to debate that, we're not going to be able to resolve the case today. I also agree with Stacie, and I'm sure you, that we're not here to ensure substantive fairness, but procedural fairness. And that's not always well accepted by the layperson. But if they understand the process, I think they do accept it, and the lawyers know it.
All right, so I think we're all in agreement on that, though, that we don't guarantee substantive fairness or outcome fairness. I want to bring up something now which has not been in my outline, so you guys haven't seen this, but it just occurred to me. Because, and Stacie, you're an academic, you teach at the Strauss School and all this. When I took my courses, the rule of professional conduct that says when a lawyer gets old, he or she must become a mediator. So when I got old, about 20 years ago, I took some courses in mediation at UCI. They had a program then. And we learned about the BATNA and the WATNA. And now we haven't talked about this now, but it's an academic thing. And the BATNA, the best alternative to a negotiated agreement, and a WATNA, the worst alternative to a negotiated agreement. I never engage in those analyses. And when I was a lawyer, and the few mediators, the mediators I worked with who did that, it just bewildered me, because to me, I couldn't answer the question. The best alternative to a negotiated agreement for me was always, I kick your butt at trial. The worst alternative to a negotiated agreement for me was always, you kick my butt at trial. So again, this was not in our outline. We didn't talk about this, but the BATNA and WATNA concepts have been something that really have never entered into my practice. How about you guys?
I mean, I definitely don't talk about best BATNA, just because it is more of an academic term, but the analysis really is this deal a good deal? Or is it better that you spend this money? What does that look like? Are there experts? How much is it going to cost you? What is going to be the net to the client at the end of the day? What are your chances for success at trial? Is it 50%? Okay, well, we can do calculations. You can even do decision tree analysis, whatever, depending on the sophistication of the case. But it is, what does it look like if you don't get a deal? I mean, one thing that it looks like is some people are so stressed out, so upset it's consuming their whole life. Do they want to go another year like this? Or do they want to take something less today? So the emotional costs, the relationship costs, the lost opportunity costs, that is part of, I guess, technically, the worst alternative or best alternative, what is the alternative to the deal? So it's not a BATNA I'm talking about, but I am talking about, if you don't settle, what does life look like? What does litigation look like for you?
I do the same. I bring those concepts up if need be, just to get people to understand there's a wide range. And sometimes you got people saying, he ran the red light, and the other party says, no, she ran the red light. And it's like a 100%. So you can say one of you is going to go to trial, or both of you go to trial. One of you is going to win, one is going to lose. What's the best opportunity today to resolve the case? So, and how is that? Isn't that better than the emotional trauma, the expense, the uncertainty, and the delay of reaching a conclusion? So I use it frequently, actually, as trying to get people to start thinking about settling the case rather than telling me why they're going to win the case at trial.
Yeah, so I think we all kind of do the same thing, but we use different words and our own personalities and our own approaches on that. Along these same lines, in all of my introductory talks, I cite statistics on the percentage of cases that settle. And the numbers I see range between, say, 95%. I was told in the Central District, the number was 99.5%, that such a huge percentage of cases settle. And I talked to litigants about why, and I talk about the two main reasons they settle, one being the expense of taking a case to trial, the lawyer's fees, the expert witness fees, the deposition reporters, and all that stuff, and how very often the amount spent by both sides on a case exceeds the amount they're fighting about. Exceeds the amount they can settle for. So I say that's the one.
And Michael, as Stacie mentioned, the emotional expense too.
Yeah, no, yeah, that's the next thing. But as to the top two on my list, the other one is the uncertainty of it all. What I say is, as lawyers, your lawyer and I have chosen a profession where we can't guarantee anything. I know your lawyer is very good. I've worked with him before. I know he thinks this is a winner for him, but he can't guarantee that.
I know.
I say, but those are the two reasons that 98% or 95% of all cases settle before trial. I do, Mike, mention also trials are really unpleasant things. The discovery is unpleasant. The trial is unpleasant. Every aspect of it is unpleasant. You're going to be characterized in ways that you're not going to recognize what they're talking about. So I think we all do kind of the same stuff in different ways.
Mike, you brought up the point of you can't guarantee as a lawyer what the result will be. I do talk about this, and I do think lawyers need to think about this. Lawyers tell me all the time, I lost a case I thought I'd win. I won a case I thought I'd lose, because your decision maker is a stranger. And they come in with past experience, with past headsets. So they may decide your case based on nothing to do with your case, but they may just be inclined in a landlord's favor or an employer's favor because they can sympathize with that. they've had a similar experience, and they also have implicit biases they don't even know about. And it might be a cultural implicit bias. It might be physical, somebody's physicality or their name or something. So there is so much risk with trial that it's a risky and it's inefficient, and it oftentimes, the disputes are less than it's going to cost, especially of expert involvement to get through there, not to mention the emotional. But I like that you bring up that lawyers can't guarantee it. It really is true. There is a lot of risk here.
Yeah, it's funny. On occasion, I have defense counsel. First of all, a couple of things with counsel, period. Counsel tend to believe their own, start believing in their own case. They start believing their own BS. And you've got to, that's not an impediment. That's something we have to work with. So, all right, we're gonna move on to procedural fairness now. And as to procedural fairness, we've already talked about this a little bit, but we'll go through it in a little more detail now. As to procedural fairness, the answer is yes. Unequivocally, we have an obligation to make sure that the mediation is procedurally fair. There's a good discussion of this in the California Rules of Court. The rule 3.853 and subsequent rules deal with rules of conduct for mediators in court-connected mediation programs. And slide 20 here is a excerpt from Rule 3.853. It emphasizes the voluntary nature of mediation. We'll talk about that more a little bit later. Go to the next slide, please, slide 21. There we go. That's a slide of which has an excerpt from Rule 3.857, which emphasizes the quality of the mediation process, and it's got a really good definition. In part, it says procedural fairness means a balanced process in which each party is given an opportunity to participate and make uncoerced decisions. Now, this goes back a little bit to what I think Mike said and Stacie said earlier, and I do it too, is I do let the parties vent. I let them initially tell me their story, and they express their emotions. They tell me how bad the other people are and all this. And that's even after I've told them we're not really talking about fairness, but fine, I want to hear all that stuff. But they do have to feel that they've had an opportunity to tell their case to you. Interestingly, this rule says, as we discussed under outcome fairness, it specifically says that a mediator is not obligated to ensure the substantive fairness of an agreement reached by the parties. So the conclusion that Stacie, Mike, and I have all reached on our own is codified in this rule right here. Rule 3.857 also requires the mediator to explain the nature of the mediation process, which we do, at least I do, and I'm sure you guys do too, which should include a description of the mediator's style of mediation. So as to the mediator's style, I assume they're referring to whether it's facilitative as opposed to evaluative. And I don't think my process is either facilitative or evaluative. I think it is both. I'm there to facilitate a meeting of the minds, but I also feel free to give my evaluation. That is my opinion. In fact, nothing stops me from giving my evaluation. I can't help myself. I have to do that. Stacie and Mike, how would you describe your process? And do you describe it at the outset? And are you facilitative or are you evaluative?
So similar to you, Mike, I want to say my process is fair. So I really get buy-in from the parties at each step of the project. I want to make sure they're comfortable. I'm working for them. I don't surprise them with things or do something to make them uncomfortable. In terms of style, it's a hybrid and it's whatever needs to be done. So it depends would be my answer. Sometimes I'm more facilitative than others and more evaluative than others. So it depends on the nature of the case in terms of how much involvement. The dynamics of the mediation dictate this. Relationships between lawyer, counsel, and the client can have a bearing on this. What's talked about in the mediation has a bearing on this. And I will, if it's an opinion about something that's going to get, an evaluation, which is an opinion that's going to get us past some obstacle to settlement or allow us to close the deal, I absolutely do that. And if it's a softer approach, if somebody's really cognitively biased and defensive, defensive and unable to consider new information, my evaluation might be in the form of questions or a gentler approach. So it just, for me, it totally depends on my style is always different. And it's
Stacie,
different probably hour to hour, case to case.
Stacie, do you describe your process in terms of that facilitative or evaluative or a combination to the litigants and the lawyers at the outset, like this rule seems to require?
I do not do it at the outset because I don't know which way it's going to go. So I don't, you know, the rule requires us to say facilitative or it says style. Yeah, in the opening, I talk a lot about mediation, what's going to happen, stylistic, but I'm not specific as to facilitative or evaluative. But I will tell them we're going to be we're in separate meetings and all that type of procedural stuff I do describe for them so that they feel safe and they trust the process so that, and if there's some informational difference, maybe one side's really nervous about mediation, they don't know what it's about, I will talk a lot about that at the beginning so that they know they're in a safe process and how it'll work. So,
Mike, how about you? What do you do at the beginning, and how do you describe your style, and do you tell the people what your style is?
I don't necessarily use the words facilitative or evaluative, but I start most mediations with a good opening, explaining the process, unless the attorney says, look, we've gone over all this, and the client says, yeah, I know what it's about. I still want to get a few words in about the process because I think it's important that they understand that. Particularly when I'm dealing in personal injury cases with a plaintiff, they want to be heard sometimes. And I'll ask the attorney for permission just to ask questions of the client. And when you go through that process, and I consider it more facilitative, they have the opportunity to vent, they feel they've been heard, et cetera. And then you can work off of that later on in an evaluative situation, or even, I don't use as fairness, this isn't fair very often, unless somebody's really pushing at it. But I start facilitative and if need be, move to evaluative. That's kind of what seems to happen. But as Stacie says, it depends on the parties, it depends on their the attorneys, the relationships, people that know me and have worked with me before. It's easier to get to the bottom line quicker. Other people, I think you need to go through the process. The process is critical in many cases.
Yes, so Stacie, to go back to that word which I started using in connection with this preparation, it happens organically. It just happens. It just flows into evaluative, facilitative, or whatever seems appropriate at the time.
Absolutely. And one thing you both brought up that I think is so important is that you let the parties vent and you let them tell your story. With plaintiffs, they've got this is that day in court experience. This is the first chance they may get to tell a neutral what happened. And if we're going to be able to get them to settlement, they're going to have to explain to us how horrible life has been since this situation, since whatever caused this dispute. And I do think it's very important for us to listen as the parties talk to us about this, and give them that ear so that they feel that they have this type of, I don't know, day in court feeling, but whatever, telling a third party. And that sometimes is what it takes to let them move on with the dispute. So you both touched on it. I think it's very important.
So the last slide we have in this fairness is this one here, slide 22, elements of a fair mediation. So there are many, many lists and articles, and I'm sure Stacie probably teaches this at Pepperdine, the elements of a fair mediation. So I've boiled these down to 4 things. It's voluntary, neutral, confidential, and competent. So as to voluntary, nobody can force you to agree. We're going to talk about this, Mike in particular. We're going to talk about this more later. As to neutral, that's the name of the game. We're neutrals, but we'll also talk about this more later, and Mike's going to lead that talk. Confidential, we've already talked about this, and the way I phrase it is what happens in caucus stays in caucus unless you don't want it to. And competent, this is the one I want to talk about. To me, when I see competent, it means subject matter expertise. And this is kind of a bugaboo of mine. And one of my good friends at ADR Services, Lance LaBelle, and I talk about this all the time. I'm talking about subject matter expertise. Is it necessary for the mediator to have subject matter expertise? If you're going to do a construction litigation case, do you have to know about construction litigation case? If you're going to do medical malpractice, do you have to have practiced in medical mal? I don't think it is. As a temporary judge in the Orange County Superior Court doing settlement conferences, and I said more than 1,000 of them, they just assign us cases. They assign us, even though we're on panels, supposedly I'm on the business lit panel. I have mediated as a settlement judge, medical malpractice, construction litigation, everything you can think of kind of cases, and have been able to settle them. So I've effectively handled and settled numerous cases outside of my area of practice. From my perspective, and I do want to hear Mike and Stacie's thoughts on this, but from my perspective, more important than subject matter expertise is law business expertise. This includes trial experience, discovery experience, fee charging and collecting experience, judgment collecting experience, experience dealing with clients, experience dealing with the very pleasant opposing counsel who you're dealing with, experience running a law practice, and all that kind of stuff. I think that's more important that I know what happens in real life with clients and with lawyers and with lawsuits than necessarily that I have subject matter expertise. You know, the lawyers tell me the subject matter expertise that I need in their briefs. They really do. And I pick it up. I mean, it's not that I'm that quick a study. I think everybody picks it up when we hear it from them. So Mike and Stacie, your thoughts on procedural fairness, which I think you're going to say yes, but on subject matter expertise in particular, I'd like to hear what you guys think about that. And we have not discussed this, so this will be new for me for the first time to hear this from you guys.
Well, let me start. I keep muting myself because I thought it was smart to come into the office and airplanes keep taking off. So
That's right. Mike's in our Orange County office, right across from the runways at John Wayne Airport.
right. You know, Mike, I've been doing settlement conferences for 32 years, and I always dread it. I used to dread it when they gave me a business lit case. Because I know personal injury, I know trials, I know the expense and all the considerations of getting ready and taking a case to trial, but I don't have any particular interest or expertise in this case. But I found out invariably that I would get a brief that would isolate the issues. I'd find people that were unable to afford to go to trial. And so you heard bankruptcy all the time, you heard all kinds of things. I found that I was able to resolve a lot of cases, and I didn't need to know the subject matter expertise. Now, in mediation, I think people choose you for your subject matter expertise in many cases, but the psychology of settling is broader than subject matter expertise. And you're right, the business of the law, the costs, the risks, they don't change from, you know, a landlord-tenant case necessarily to a breach of contract case to a fraud case. You've still got those same dynamics of getting ready for court and getting ready for trial and the uncertainties and all that kind of thing. So I think it's, you know, I'm going to say, I think it's important, but not necessary.
Okay, good. Stacie?
Yes, so I agree with what you both have said about this. I have found that it's never been I've done well over 1,000 mediations. I do all areas. This has never been an issue because the lawyers briefed the case for me. If you're a lawyer, I was a business litigator, but I also was personal injury, employment, some entertainment litigation. You pick up on the issues, you see the dispute. The main reason I don't think it really matters is because there's so much going on in a mediation that is important to settlement. And it rarely is turning on a legal issue. It might, we've got to evaluate that and help them understand what's going to happen for trial. But there's so many other components here. There's so many emotional, psychological, reputational costs, business issues that play into this. So this is one little facet. Now, if your whole case is patent, let's say, or bankruptcy, that might be an area that's specialized and you may want a specialist for that. Same with family law. But for the most part, I haven't found this ever to be an issue. I don't know that I've gotten it, an area that is I had never done usury law before, and that was one of my first mediations with like 5 parties, and we were able to get it settled, and usury law was totally new to me. One thing I want to add that I think can be helpful is getting a mediator with experience, because that's so much of it too. I mean, we've seen these negotiation moves. We've seen someone lie. We've seen these situations. We've used creative resolutions that work. We know how to get past barriers to settlement. And so experience, I think, of your mediator can be helpful. I'm not saying don't try a new mediator, they're great too. But that's another component in it, is how are they going to handle these situations as they arise? And I think that's important. But if you have some really nuanced area and you think your case is going to turn on the law, that's a type of situation you may want to look for some subject matter.
Yeah, so Katie, could you quickly go back to slide 18? Because I want to see that I was right about this slide. I want to tell you that I was right about this, because right at the outset of this section, I said there were 3 irrelevancies: fairness, justice, and equity. And I still believe that to the main part. But also I wrote down there, maybe also the facts and the laws. And Stacie, that's what I kind of hear you saying. And Mike, maybe you're not saying this clearly, but I believe that also. The facts and the laws become way less important than all the other stuff we've been talking about. All right, so thank you, Katie. I guess we're now on slide 23, possibly. There we go. Lying and mediation. And hold on a second, let me get back to my notes here. All right, so we're going to talk about lying, fibbing, misleading, anything else you want to call it in mediation. Next slide, please. Is it okay to lie to the mediator? Stacie and Mike are going to weigh in on this in a few minutes also, but I don't think this is really the right question to ask. Next slide, please. So I have some Mark Twain quotes here. I have learned that I can never do a presentation without quoting Mark Twain. So that's why those are here. There is one more Twain quote on lying. If you tell the truth, you don't have to remember anything. So I expect counsel to lie to me. I expect them to not tell me the full truth. The real question is, what do you do about it? And the answer is you work with it. It's part of the fabric of what we as mediators do. Fibbing, lying, it's like beauty. It's in the eye of the beholder. Yeah. Next slide, please. Slide 26. Okay, so these are some of the more common areas or areas that I wanted to highlight as to where we get, it's called lies, but sometimes it's exaggeration, sometimes it's failure to disclose, sometimes it's just a little bit of a fib. But lying about bottom lines and top lines happens all of the time. I think everybody knows that. I expect it. I welcome it. In fact, I often tell counsel that I do not ask for top lines or bottom lines, especially early on, because everybody lies to me anyway. They always chuckle about that, and it's really an acknowledging chuckle. But then I say, lie to me a little bit. I want you to lie to me a little bit. Say, without it binding you, without me communicating to the other side, just lie to me a little. Give me your bottom line with enough of a fudge factor to make you feel comfortable. Again, it's not going to bind you. I just want to get some idea. Give me some idea what it will take to get this done today. Usually, that yields useful information. So along these same lines is the last, best, and final. Counsel also often give me a number and tell me that it's their last, best, and final. That's it. It's our last, best, and final. I used to try to talk counsel out of doing that. Gee, that's going to end the mediation and all this. I don't do that anymore. In fact, sometimes to move things along, I encourage counsel now. Give me your last, best, and final. Just give me it. Give me your last. I feel okay doing this because I've rarely met a last, best, and final that is last, that is best, or that is final. It happens all the time that a last, best, and final is met with a counter. Last, best, and final, and then you start negotiating last, best, and finals. I don't consider this lying, by the way. It's just the way things happen. Of the items on this list, one that gets me to the most is counsel telling me that the decision makers are present when it's clear to me when they are not present. Back in the courthouse, when we used to do MSCs years ago, like Mike said 30 years ago, before cell phones, you could tell when the decision makers weren't present because counsel would get up and run down the hallway right by the bathrooms in Orange County Superior Court and get on the payphone. and you knew they were calling each time that there was an offer or a demand made. The hardest person to settle with is the person who is not in the room, whether that's the handling adjuster, the adjuster supervisor, the supervisor, the trial lawyer, the boss, the partner, the husband, the wife, the lover, the lawyer cousin, the hairdresser. When the real decision maker isn't there, that makes it very, very difficult to settle. For MSCs, there are state court rules and local rules that require the attendance of all the decision makers. For example, LA Local Rule 325D. What I think is really, really interesting about this rule, and I didn't know about this part of the rule until I prepared for another program I did a few months ago. If you look at section 4 at the bottom, it requires lien holders to attend or be available at the settlement conference. So I would say that never, ever happens. I've done, I said, 1,000 settlement conferences, 500 mediations. I've never had lien holders present. Usually a plaintiff's counsel is scrambling around at the very end of the mediation trying to get lien holders on the phone. But I think it'd be fantastic if the lien holders were at every event. It would make things go so much smoother. Next slide, please, slide 28. So this is the OC, Orange County Superior Court rules, which are ones that I have lived with for the last 50 years and which I do teach about. The OC rule has a line that often comes into play. It says, an appearance by an attorney claiming to have settlement authority does not satisfy. Often enough, counsel will show up at mediation and at settlement conference and tell me that counsel, he's without a party representative, but tells me I have full authority. Rarely do they have that authority. When I'm sitting in court as an MSC judge, I can do something about that and say, you know what, get your party here. Private mediations don't have those rules, although court-ordered mediations often do. If you go to the next rule, slide 29, please. This is part of order number 11-10 of the, whoops, we just, hang on one second. Well, what it is it's part of order.
Sorry, I'll get it back up.
Okay, hold on one second.
Go ahead. I will pull it back up in just a moment.
Okay, it's from the Central District, and it's part of their general order 11-10 on ADR, and talks about settlement conferences, not settlement conferences, excuse me, mediations on the court panel mediations. It says in part, and I'm not going to read the whole thing, obviously, each party shall appear at the mediation in person or by a representative with final authority to settle the case and who is knowledgeable about the facts of the case. Representatives of insurers with decision-making authority are required to attend. And that's my biggest bugaboo, because that often does not happen. Sometimes there are these third-party administrators that come, who, as far as I'm concerned, have no authority, as far as I can tell, have no authority and really don't know about the case. And Mike, I'd like your weighing in on all this when we get a chance here when I'm done, because you've had a lot of experience with this. It also says each party shall be represented at the mediation by the attorney who is expected to try the case. Now, often you will not get the trial attorney. Rather, you'll get an associate who may or may not be on the trial team, and the associate, you'll ask where the trial attorney is, and the answer I always get is always the same. The trial attorney is engaged. And so oh yeah, what's that mean? Nobody seems to know where they're engaged, but they're definite that she is engaged somewhere. How about lying about the law of the case? I don't worry about that too much, because if counsel tells me the law incorrectly, opposing counsel is all over that. Immediately as I communicate, well, this is what I understand the law to be, counsel's telling me this, they completely tell me it's wrong, and they start citing cases and all that. So sometimes this works to our advantage, I think, as mediators, because I will carry this argument about the law back and forth a few times. I don't want to waste the whole mediation on it, but I carry it back and forth a few times. It's in front of the clients, in front of the litigants, and then I use it to show the litigants the uncertainty of litigation and why a settlement is better. You know, your lawyer is saying the law is such and such, and I know your lawyer, she's a really good lawyer, and I think she knows the law. But the other attorney is saying this is the law. There's no guarantee, even if your lawyer is right, that the judge, the jury, or whoever's going to decide on law is going to decide that way. That's why you need to settle this thing. It's the same thing about lying about the facts. I rarely convey facts from one side to the other as if they are facts. I say, hey, this is what the other side's telling me, and I can't vouch for it. And again, counsel will quickly tell me if they think it's BS. And that happens all the time also. But also it's another good learning or teaching moment for me to say, hey, look, you guys are saying these are the facts. They're saying these are the facts. I don't get to decide that. But I know you very strongly believe you're going to prevail on it, but there's no guarantee you're going to prevail on that. And that's another reason we got to settle this. Another area where truthfulness is often questioned is statements by defense counsel of their client's inability to answer in damages. Almost always, when I hear this, and you let them know it's not going to do any good. They can get a judgment against us. They're not going to collect a penny, and we're going to go bankrupt and all this stuff. Almost always plaintiff and plaintiff's counsel will say, and this is almost invariable that this happens. Plaintiff's counsel and plaintiff will say to me, that is a lie, and will tell me that the defendant lives in a house on the beach in Laguna, drives a Maserati, has a house up in Mammoth, and all this kind of stuff. I've told counsel that if they're going to rely on insolvency as a defense, it would be best if they show some proof of that, like notices of default, actions filed against the defendant, credited Dunning letters, stuff like that. And I've had mediations where defense counsel has just come prepared with all that stuff, and it's worked to their advantage. So we can go to the last slide on this area, which, oh, you're there already. Okay. This is, no, one slide back. I'm sorry. There we go. This is California Rules of Professional Conduct, Rule 4.1, truthfulness in statement to others. It says, in the course of representing a client, a lawyer shall not knowingly make a false statement of material fact or law to a third person. This has been interpreted both in the ABA model rules and in these rules as applying to negotiation mediations. But take a look at the comment to the rule. I am going to read a portion of this. This rule refers to statements of fact. Whether a particular statement should be regarded as one of fact can depend on the circumstances. For example, in negotiations, certain types of statements ordinarily are not taken as statements of material fact. Estimates of price, value, a party's intentions as to an acceptable settlement or of a claim are ordinarily not in this category. So all this the authorities seem to be saying the same thing. You can engage in puffing in negotiations. You can try to sell your case to the mediator, to the other side. You can try to sell it yourself to yourself, but you can't knowingly misrepresent the facts of the law. This is the same as when you're arguing your case to the court in a brief or orally. Where trouble arises, I think, is because of mediation confidentiality. And Stacie touched on this in depth. Because of the mediation privilege, some counsel seem to feel more free to spin the facts, lie about the facts, and the law in mediation. Since it's all confidential and can't be used by the other side, some lawyers seem to feel it's okay to play with the truth. But as we have seen, as Stacie has pointed out, the mediation privilege is not absolute and does not shield a lawyer or client from misconduct. So Stacie and Mike, what are your thoughts on lying and all the stuff I've been talking about?
I agree that there's a lot of puffery that goes on. I accept that. I agree that I don't believe that the attorneys are telling me complete truths, particularly when they're talking about dollars that their bottom line, their top line. That's just part of the nature of the mediation. I listen carefully for how the attorney phrases their questions. We would never want to pay that. Which means, of course, that's kind of a loose language. But if they tell me $1 million is all we have in terms of policy limits, and after that you have to do that, I expect that to be a truth, not a lie. They can't. So there's a difference between puffing on intent and advocacy, advocating for a client, and actually lying about a fact.
So, Mike, I want to ask about that because that happens a lot where I hear from insurance counsel, the adjuster, that we not about policy limits. I don't expect them to lie to me about policy limits, but they come in and say, all I've got is whatever the number is, $75,000. That's all I ever have. We can never, ever go over that number. oftentimes they end up going over that number. So
Well, again, listen to what they're saying. I only have $30,000. That's it. There's no more. Okay, that's the authority that they walked into the courthouse or mediation with that day. And to get any more, they're gonna have to go up the ladder. Okay, and most of these cases, the carriers will evaluate them ahead of time and think that's enough money. The plaintiff doesn't think it's enough money, and then you go back and forth. And MSCs, and you know, as long as they're engaged in good faith negotiation, I'll tell them to go make a call, I'll tell them to talk, and you know, we give money sometimes, but listen to what they're saying. And it's just they're just the nature of the way the business is set up. When you get to certain levels, you need someone else's okay.
And just to jump in quickly, because I want Mike, you to get on to your subjects as well. I agree with everything you say. I expect lies. They happen all the time. I don't know if people know they're lying, you know, and I just want to point out that people have different truths anyway of the same situation. They could, one could think it's red and one could think it's green, the light's green, and that they really believe that. Lies about the law, trust me, the other side will be very happy to tell us that that's not true. I never carry a known lie. So I've had somebody say, I'm employed, but tell them I'm not. I wouldn't do that, and that wouldn't be productive. So you might want to counsel your clients not to do that, because then the other side's not going to listen to you. They're not going to want to work with you to arise at a settlement. They're not going to want to meet your interests and needs. So to just do a lie that, you know, somebody said, I haven't been to the gym since the accident the other day, and the other side pulled out gym records. He's there like 4 times a week, and they have video of him in the gym. Like, that's not helpful in terms of getting the defense to want to give you more money. So just keep in mind, if your client's lying, it's not as a mediator, I don't care. I expect some of it, especially with negotiations, it's all the time. But just keep in mind what helps your client get the best settlement result. And lying about bottom line, that's a negotiation tactic, that's fine. And it's up to the other side to push against that anyway. But lying substantively when it's just not true it's not good for you, your client, in terms of end result. But I do want to kind of move us along, because Mike, I'm worried that you're not, yeah, there we go. Get to your presentations.
As we discussed neutrality, I think it's important to remember the underlying concepts we've already discussed of self-determination, voluntary participation, and procedural fairness. In terms of self-determination, the model standards of conduct promulgated by the American Bar Association, the American Arbitration Association, and the Association for Conflict Resolution has it as standard number 1. And it's also, as Mike just pointed out, it's in 3.853 of the California Rules of Court. In essence, they say that a mediator shall conduct a mediation based upon the principle of self-determination, that they shall have the parties come to a voluntary, non-coerced decision made free of and informed as to the process and the outcome. And a mediator shall not undermine self-determination. So how does that impact neutrality? Next slide, please. First, I think it's important to define what is neutrality. I think it may be defined as a mediator's lack of interest in the substantive outcome. It's the exclusion of personal feelings, opinions, and beliefs, remaining indifferent as to the result, not arriving or developing a personal stake in the dispute, and not having a desired outcome other than a self-determined party resolution. Those are how the purists would describe neutrality. And how does that differ from impartiality? Impartiality is really more of the behavior of a mediator. It's the absence of demonstrating any bias. It's the absence of having any bias in relation to one of the disputing parties or more. No favorites, in other words, treats everyone the same and doesn't take sides or exclude anyone. So I think those are the definitions of neutrality and impartiality. Next slide, please. So why is neutrality vital in mediation? Let me start by saying trust is the neutral in the neutral is absolutely critical to a mediation. The process has to be trusted by the participants. Confidence in the process is critical to its success. And the neutral has to be seen as neutral, as a buffer and a facilitator to encourage settlement. Stacie and Mike, do you have any input on why neutrality is important and vital to a mediation?
Well, I think you hit on it. It's the trust factor. If either of the parties don't trust you, you're not going to get very far in negotiation. Interestingly, on this, and I think it's something we've all had, and as a lawyer, I did this too, is often people will select me. Let's say the defendant will select me as the mediator because the plaintiff wants me as the mediator. And the plaintiff has expressed that they've had success with me, they like me or something like that. And the defendant says, good, I want you to have your mediator because Mr. Balmages or Mr. Maguire or Ms. Hausner is going to tell you how bad your case is. And you're going to listen because you like them. So, I mean, they may not think I'm neutral, but they may think I'm valuable in that case. And that.
Stacie?
Yeah, I mean,
I think that's correct. I think they trust me and they trust us. They trust that we're going to, go ahead. Stacie.
I agree with everything you both have said. Neutrality is the cornerstone. If I was on one side, that just wouldn't work. I would have no influence in moving them towards settlement. So even if I know lawyers, I work with some lawyers frequently, and lots of lawyers are repeat, I'm still neutral. I can't get one side the deal, right? Both sides need to agree. And so my neutrality, my no stake in the outcome, that's why I can't police for outcome fairness. By having no stake in the outcome and helping them to reach whatever deal works for them is critical. And it is the trust and rapport. They do studies on this, by the way, and they found the number one factor at moving people to settlement is trust and rapport, more than intelligence, more than subject matter competence. All the other factors is being able to connect, because that's what allows us to influence and persuade the parties to see the dispute similarly and get to settlement.
I agree. And neutrality is at the center of it.
Yeah.
So there are differences of opinion in the ideal of a mediator's neutrality. Jurists examining the standards see the mediator's role as more facilitative. And the concept of the mediator offering evaluation is in tension and possible conflict with the concepts of self-determination and neutrality. On the other hand, the mediator, it is equally important to remember, has a core duty to aid is there to aid the parties in reaching a consensual agreement. The mediator's input and intervention is often needed. So it's important that intervention, which may be needed, doesn't cross the line of neutrality, that the mediator that resists steering the parties to a desired result from the mediator's perspective. The key is in finding the right balance between offering evaluative input and maintaining neutrality. And I'd like to ask Stacie first. Stacie, with regards to influence, when would a mediator's influence, by, in sense, intervention, cross the neutrality line?
I love this question. I think it would okay, so I'm looking for influence. I love influence because that's how I'm going to get your case settled. I think it would cross the line if I was taking away free will. And because I mediate cases where parties are represented by counsel, I'm really not worried about that. That's the lawyer's job, right, is to help make sure that the client is acting in their best interest. So in terms of influence, I'm not worried about that compromising my neutrality. Now, I don't pick a number I think this case should settle at. In that case, if I were doing that, that wouldn't be so neutral, right? And that would be using influence to kind of choreograph. Well, I try to choreograph productive negotiating behavior. But if I were to pick the outcome and the number that it was going to and direct everyone to it, I think that wouldn't be so neutral. Now, I'm excluding mediator's proposal as a settlement tool from saying picking the number. And we're going to talk about that in a bit, but I am looking for zones of agreement. I'm influencing people into a zone of potential agreement. We call that a ZOPA. And then it's once I'm in there, I know the case is going to settle, and it's up to counsel to get as much value as they can within that zone. So I'm not really ever worried about too much influence. If somebody said, should I settle? I've had that happen, or should I take this number? Mike addressed this earlier, and I agree with Mike. I don't tell people what to do. I would assess with them the pros and cons to doing it. What about you, Mike?
Well, okay, so Stacie said something a little while ago about studies show that the key ingredients are trust and rapport. I would phrase it differently. In my experience, it's rapport and persistence. And the question, and I discussed this with a little bit of with Mike before we got started today, in developing rapport and in my persistence, do I cross the influence neutrality line? So I try to develop rapport. And the way I do that is by talking. I talk about where the parties live, their hobbies, their grandkids. I talk about the Green Bay Packers. I talk about my Cal Golden Bears. I talk about, as I said, my grandkids. And it generally works. I develop rapport with the parties. I talk about my astronomy hobby, and they are interested in that and all that. I talk about anything but the mediation, and I find some common ground where they grew up. They grew up in Brooklyn, where I was from, or something like that. And I develop rapport. So I wonder, but let me finish about the persistent part before you answer this. I wonder if that's too much influence, making them like me like them kind of thing. The second thing is the persistence. And I think that's possibly the most important thing, is I just keep working it. I kind of like never, ever give up. Even when the parties have told me, hey, there's no way we're going to get this done. Thanks for your efforts. We don't want to waste any of your time. We don't want to waste any more of our time. So let's just call it, let's stick around, just stick around a little bit longer. I'm going to go talk to the other side. We've all closed bigger gaps in this. Just stick around. So here I am.
Michael, let me ask you this. How do you think that affects your neutrality or impartiality by being persistent?
That's the question I'm asking you guys, actually.
I don't think it does.
I don't think it does. And let me tell you, I'm the same exact way. I would try absolutely everything to get this case settled. That's what I think they're hiring me to do. I will not hurt their case, but I will do everything. Even if it didn't settle on that day, I will stick with it and continue to be persistent. And I never feel that's crossing neutrality because I'm helping both sides. So I'm neutral.
Well, same question with respect to evaluations. Do you think that affects a mediator's perceived impartiality?
If you were doing it in a joint session, I think you'd have a problem, because then it looks like you're railing on one side. The other side's going to be cheering as you're pointing out weaknesses on the other side. But as long as you're doing this in caucus and you're just evaluating the case with them. What are the pros? What are the cons? What are all those things you're doing in both rooms, because you're wanting them to move towards the other side and get their evaluations of the case more similar. So I don't see it as a compromise of neutrality. I evaluate. I don't walk in and say, here's what your case is worth. I would never do that. I'll evaluate an issue or a problem just to keep moving us. It's a tool to settlement. It will move us past barriers and obstacles. And I do it with everyone because I got to get them to see the case more similarly. And therefore, I don't think it has any impact on my neutrality. What about you guys?
Well, I don't know about having impact on neutrality, but I often, when they ask me to evaluate, I generally don't give them an evaluation other than saying, look, if I handled this case 100 times, it would settle between 25,000 and 45,000. That's my experience. This case settles in that range. Almost always counsel agrees with me when I say something like that. So I've had very little pushback on that. Sometimes they say, well, this one we think is worth a little bit more or a little bit less for this reason. But Casey, you said something interesting about picking a number. You don't pick a number. Many times within the first few minutes after I met with both sides, I write down on the legal pad and circle it for my own, I write down a number, $365,000, whatever the number is, I write it down. And then so often the case settles there.
I know.
Am I unconsciously Am I
Yeah.
unconsciously driving it there? Maybe. I don't know the answer to that. But not, I put down 365, it settles at 380, or it settles at 350 or something like that. I think with all of us, we've done this enough times that we've got an idea fairly early on where the thing's going to go.
Yeah, we
Well,
can
Mike,
see the
I
concession.
agree with you. And I think it's just important that the mediator is careful not to steer the negotiations to the mediator's perceived value. And we need to move on, if you don't mind. Next slide, please. Mike, I would like to discuss a type of intervention, and that is mediators' proposals. You mentioned that earlier, Stacie, that there is a way of you mentioned that mediators' proposals may touch upon neutrality or perceived neutrality. So, Mike, why don't you start this conversation off?
All right, I will. So this is a slide that I have used in many presentations that I've done. I would have read them all if we had more time, but I'm not going to do this. But the experts basically don't like media's proposals, and they talk about the lawyers, the mediator running out of skills. They also don't like lawyers who like media's proposals. Unfortunately, I think many counsel looking for a media's proposal are more lazy than savvy. So I just wonder where these people went to, where they practiced in this world. Do they practice in this world? Because this is not the way it works in the real world. Again, to use a phrase which I never used prior to preparing for this, media's proposals for me come up organically in the course. And sometimes defense counsel wants me, absolutely wants me to say, look, like Mike said, we've got authority of $75,000 here today. We'll go back and ask for more, but we need something to base it on. Give us a media's proposal with your evaluation. If it's above 75, at least we can go back and say the mediator thinks it is worth 75. I try to tell them if we so talk about too much influence. Let's go to the next slide, please. If we can get there. All right, so this is a real life thing for me. Am I having too much influence here? I have done this dozens and dozens of times where I make a media's proposal, and I do it just like this. I take a legal pad, and on 2 pieces of paper, I write down a number. Hopefully it's the same number, otherwise I'll be really causing trouble. But I write down a number, and I've been a big yes and a tiny little no, and I give it to counsel and say, hey, you know what? Sometimes they want days to think about it. Sometimes they're going to think about it right there. And I said, here it is, with the encouragement that they check yes. So I'd ask, and my media's proposals are based on what I call the art of the possible. Really, I mean, it's not more sophisticated than that. How low do I think I can squeeze the plaintiff down today? How much do I think I can squeeze out of the defendant? I often tell that to counsel because they say, "Oh, this is your evaluation of the worth in this case." And now this is what I think we can get it done at. This is what I'm talking about. So one lawyer once called me on that, and I think maybe rightly so, but I'm not going to do anything about it. That lawyer said, "So wait a minute. So the more obstinate party, the more unreasonable party, kind of gets favored by your approach." And I thought about it, and that lawyer's probably right. But my job, I think, like Stacie said, is to settle the case. I don't like to do media's proposals that nobody's going to accept. I like to think at least one side's going to accept them, and generally both sides do. So I try to pick something based on the art of the possible. And again, this is a real life thing that I do. Go ahead, Mike.
I was going to let Stacie talk about her approach to mediators' proposals.
Yeah, well, first of all, I love this box and putting yes in really big words. He's looking for influences as a subconscious influence on people. I use mediators' proposals as an end of the day solution if I can't get you there actively in the mediation. I oftentimes, we need it sometimes because decision makers aren't in the room. So I did one involving some cities and a county, and cities need to go back to city council. Sometimes we need board approval. Sometimes the adjuster needs to go get more authority, goes to the next level, and they've learned a lot in the mediation, so they need a proposal if I'm going to extend it. I typically know The number I could get everybody to uncomfortably, no one would be thrilled at. And it's because I'm reading the concessions and I'm listening when you're talking, and I have a sense of where it could go. And so they're generally accepted as that. There's active mediator proposals, we call them hypothetical offers. I like this, or the what ifs. So you can essentially, if you don't need somebody to go and get more authority, which is mediators proposals are necessary for that. Sometimes we can do, look, if I could get the other side to 500,000, can I get you to 500,000? Those types of hypotheticals have the same impact if the additional authority or the outside decision makers aren't necessary. I make mediators proposals with a time expiration. That's because I know from social scientists that scarcity has an impact and people are more inclined to accept it if I have a time component. It's fleeting. So I always say, how long do you need? 48 hour. I have one out right now for 48 hours, but typically longer. It is a settlement tool. It's when everybody won't move any further that day. This is another shot. Now, typically, I know once in a while, I just did one. The plaintiff stopped at $1 million. The defendant was at 50. And they asked me for a mediator's proposal. Well, that's going to be a shot in the dark. And they asked me for a detailed evaluation. It was a pre-lit matter. So sometimes I'll do that. They took it. The case settled at like 385. But I did a detailed analysis separate for each side so they didn't see it, the other sides. So that they could take it to decision makers out of the room, and I could get some more authority on the defense side and bring the plaintiff down. So I'll even do that. So I talk to the parties. I don't throw it on them. I don't give them when they don't want them, because I don't want to ruin their case. If they don't want a mediator proposal because there's a strategy for litigation, I'm not going to force one on. But I will talk to them about it, and I will use it as a last minute tool.
Okay. So Michael, any real differences there for you?
No, I mean, I agree with, I don't use it necessarily as a last minute tool. Again, it's organic. It happens when it happens. Sometimes it happens earlier, sometimes it's requested. And I told you guys, I remember at least one time, but maybe more, when I've given media's proposals, even after the parties said they didn't want them. I mean, I sent a follow-up letter after the mediation saying, nice working with you guys, and here's my evaluation of the case, which I told you guys anyway, and here's my recommended settlement. I'll keep this offer open. Both of you can reply. And it actually, I remember the case where it worked. So I use it when I think it's appropriate.
I use them judiciously. Usually when we've reached an impasse, the question is who decides, who initiates the concept of mediator's proposal. Typically, I've had cases where one of the parties suggests it. I ask the other party, are you interested? If you're both interested, I'll do it. If one is not, I won't. Then the double blinds protect them. What about the ethics of letting one of the parties propose the mediator's number?
That's a great question. So they want to do this. They're like, you bet you need to make the proposal at this. I won't accept it if it's not. The truth is, I can't necessarily get the other side to that number. So I got to pick a number both sides will agree to. So as much as a party wants it, it doesn't mean the other side can get there. And I would say to them, look, they're not going to go to that number if that's the case. If I think there's a chance, I could say there's a 50% chance they'd go to that number. I don't know if this is your best strategy. If it's a little higher, maybe they'll take, and I'll just talk with counsel about it. But it's not a bad strategy, you lawyers out there, to try to influence your mediator to a certain number. And maybe it's being stubborn. Maybe it's saying there's no way in the world I'm going to take something different than that. You can try to influence us. We do this all the time. So we know how to do it and how to make it so it can be most likely to be effective.
I do it every kind of way there is. Sometimes I'll say, if I make a media's proposal at such and such, would you guys accept it? And like Mike said, I listen to the response. Well, we probably wouldn't. I don't think we would, as opposed to, no, there's no way we'll ever take that. So I listen to what I hear from the lawyers. And and act accordingly.
Yeah.
Thank you. Okay, Katie, could you also go to slide 44? And we're going to talk about civility in mediations. How does incivility impact mediations? I submit that incivility decreases the chances of resolution. It's not conducive to settlement. It wastes valuable time with the mediator trying to deal with the incivility. And this is even in individual caucuses, not joint sessions. It clouds meaningful analysis. It justifies in joint sessions. It justifies reciprocation and vilification. And civility, I mean, civility is really what it's all about in mediations. If you approach the process with a desire and motivation to settle the case, you're gonna do much better treating people well, engendering a positive collaborative environment, and having positive interactions. And that's even with the mediator. I found more incivility in MSCs, settlement conferences, than in mediations. And I think it has a lot to do with the fact that mediations are voluntary. People are paying to be there. They want to resolve the case by definition. That's why they're there. Whereas settlement conferences are not, and sometimes they're just not ready for a settlement conference. And I think that a lot of mediators now don't do joint sessions or have strayed away from joint sessions, particularly here in Southern California. And I think civility or incivility instances has a lot to do with that. Mike, do you have any thoughts on civility, whether it's a problem in mediations or any other thoughts on how it may affect the success of a mediation?
Well, I haven't had too much incivility in mediations. I like you in settlement conferences, it's much more common than it is in mediation. And sometimes it has a silver lining because the other side, when I come back from one room and go into the other side says, well, I'll bet that was fun for you. That guy's such a jerk. And I'll say, one of the reasons you may want to get out of this case is because if you don't, you're going to spend 2 years with that friend of yours in the other room. I don't necessarily, so I kind of try to use it to my advantage, but we discussed this before, and I have not had much incivility towards me in mediations. In settlement conferences every once in a while, but they're easy to solve there because I just say, thank you, let's go back up and see the judge. And you don't want me to handle it? Great. And the judges always take the side of the temporary judge in that.
Well, thank you, Mike. Stacie, in the interest of time, I'm going to move on to the next slide. I wanted to talk about civility rules that are being proposed by the state bar. So there are 3 things before the state bar, and the interesting thing is they're out for public comment now. Up until January 30th of this year, anyone in the public can comment on these. The first one that we're going to focus on today are changes to the rules of professional conduct that would make incivility subject to disciplinary action. The second one that's being considered is changes to the MCLE program, required subjects, and making 1 hour of civility training required during compliance training period. That wouldn't increase the number of hours necessary to be one of the 25. And the third is to require attorneys each year to subscribe to the oath that new attorneys subscribe to. As an officer of the court, I'll strive to conduct myself at all times with dignity, courtesy, and integrity. And again, that's available for public comment, and I'll tell you why before this session ends. Next slide, please. Okay, Rule 8.4 describes it is current. This is what it describes. It says it is professional misconduct for a lawyer to engage in conduct that is prejudicial to the administration of justice. Next slide. Rule 8.4, this is proposed addition. It's a new comment to Rule 8.4. And a lawyer's violation of paragraph D, which I just read, includes engaging in significantly unprofessional conduct that's abusive or harassing in the practice of law or related professional activities. Mediation is a related professional activity in practice of law. And the lawyer does not violate paragraph D by standing firm in a position in the client and protecting the record for subsequent review or preserving professional integrity. And a lawyer should be guided by the current California Attorney Rule guidelines for civility and professionalism. Next slide, please. Okay, this is new rule, brand new proposed rule, rule 8.4.2. In representing a client, a lawyer shall not engage in incivility in the practice of law or related professional activities. For purposes of this rule, incivility means, and you can read it by going to it, significantly unprofessional conduct that's abusive or harassing and shall be determined on the basis of all facts and circumstances. Next slide, please. So the state bar is considering adding this to the rules of professional conduct. And they protect First Amendment privileges, et cetera. Next slide, please. Okay, next slide. I rushed through that, but I think it's very important. Next slide, please. These resources we provided, they provide links to the California Judges Association that has these same proposed rules, and the state bar, which has these rules regarding incivility, annual civility pledge, and MCLE. You can go there and in 5 minutes, you can make a public comment. It's a couple of clicks and you can comment 1 or 2 sentences, or you can attach your brief article or a long-winded objection or support for them. I think it's really important. And in talking about civility, whether it's in mediation or practice of law, the state bar and Judges Association and Judicial Council to some extent are very interested in ensuring civility in the practice of law. I encourage you to take advantage of these resources. There are articles written by Stacie and Mike here, and an article by the California Civility Task Force, which led to these proposed rules. Sorry for rushing through here at the end, but I wanted to get that in. Thank you very much, everyone, for attending the session.
2 hours is a long time, so we appreciate your attention and attendance.
It wasn't quite long enough. We needed
Yes,
more.
thank you.
I know, shockingly.
Well, you have a lot of material to cover. There's a lot to think about, clearly, in the ethics of mediation. So thank you all for sharing your insights and your knowledge and your vast experience with resolving disputes in these matters that do come up. One question that I did want to address, if we have a moment, just to ask one, we got a lot of questions early on, Stacie, in your section about how confidentiality relates when there is a public entity where the settlement needs to go before some kind of governing body. How do you square that with settlement or with confidentiality privilege?
It's going to be tough. California isn't specifically opening it under its main evidence code sections. So I'm not sure what's going to happen there. If it has to go in front of a public entity, I don't see how it can't be admitted into evidence. So I would think it comes in too. I mean, that's the whole problem. It's just not so protective, this confidentiality statute.
Well, bummer there. Well, thank you all for your time today. We really, really appreciate your speaking in today's program. Everybody who was sitting through this one and enjoying the program, your MCLE certificates will follow by the end of the day tomorrow. We do have a brief break in the next 10 minutes or so before we get started at 3:45 with our implicit bias program. Please feel free to tune out, get a glass of water, use the restroom, and we will come back online just a few minutes before 3:45 for our next presentation. Thank you so much to our speakers.
Katie, thank you very much for the
Thank
work
you,
you've given
everyone.
to this.
Thanks, everyone.
Enjoy the
Sorry for
rest
rushing
of
at
the
the end.
day. Take care.
Bye.
Bye.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront. Woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.